Hey there, I'm estate planning attorney Paul Rabalais, and in this video, we're going to address an estate planning case study. Let me give you an example. It's one I've worked with many, many times, hundreds, maybe thousands of times. Let's say, for example, we've got a couple and they're about 60 years old. Let's say the value of their total estate is $6 million. Let's say they have three kids from their one marriage. They kind of consider themselves boring. That's what they tell me. They said, Paul, we're pretty boring. We've done a pretty good job saving, but just one marriage, three kids. All the kids are grown. The kids are responsible. We don't have any kind of business or anything we want to specifically leave to one of our children, other than maybe some personal effects. And maybe this couple has never done any estate planning in the past. Quite frankly, that's common for people who are 60 and who have been busy working their entire lives. Or maybe they have some old wills that they did 25 years ago when their kids were young and they wanted to make sure they designated the right guardians for the minor kids, but that issue no longer relevant. All right, so the first thing we do in a conversation with people like that is we ask them what their goals are. What is it that you want to accomplish? What do you want to make sure we address as part of this overall discussion about making sure all your estate legal affairs are in order? And their answer was, we just want to make things simple for us, simple for the surviving spouse, simple for our kids. We want to avoid a bunch of hassle in settling the estates. They mentioned wanting to avoid probate. They also said they want to make sure that they take care of their surviving spouse. The couple had worked together, been married about 35 years, and they felt like, they wanted to make sure that the surviving spouse was taken care of, but they also wanted to be fair to the kids. They wanted to treat the kids equally. They wanted to protect the children's inheritance. More on that later. And of course, they said, Paul, we've been paying this income tax and capital gains tax our entire lifetime. We're kind of sick of paying tax. We certainly don't want our estate to have to pay any more tax than absolutely necessary. That was kind of a big deal to them. So now that we know what the objectives, let's start with leading them through the decisions that people in those circumstances with those goals, what kind of decisions are they making? So when we start the conversation, I like to start with something that's kind of simple. I like to start at the end and then work my way backwards. And so when I tell them I start at the end and I work my way backwards, might be a conversation like, okay, even though it's very unlikely that you're both going to die at the same time, for purposes of getting started and kind of getting us where we want to be, let's start at the end. And while it's likely that one of you will pass away and then the other one will pass away later, just for purposes of our discussion and to get it rolling, let's take the unlikely scenario that you both pass away at the same time. How do you want things to go? Well, they were like, looked at each other and they were like, we're pretty sure that after we both pass away, we want everything to go to our three children equally. They said our kids are, a couple of them are just under 30 years old. One is a little bit older than 30, 31. And so, when kids are in that 30-ish age range, I kind of have to ask, okay, are they at a point in their life where they are old enough and responsible enough where you have 6 million, let's say they each inherit 2 million. Are they old enough and responsible enough to be able to manage their inheritance for themselves? Or are any of them, in a condition where you'd want to set their portion in a trust for them, have it managed by someone else for a period of time, kind of doled out to them over a period of years, and we can discuss all of those circumstances. And I felt like, no, our kids are doing well. In fact, the husband said, geez, my kids are more responsible than I was at that age. We're comfortable just leaving it to them, let them handle it for themselves. So once we figured that out, then we started talking about, well, let me throw this kind of divorce protection for the kids out there. Some parents really like the idea. Some parents think it's not necessary. So here's the deal. You have a $6 million estate. Yeah, it's likely it's going to grow over time, but let's just call it $6 million and you both pass away. Each child's inheriting $2 million. If you just leave it to them outright, the moment that they get it, it's theirs and theirs only. But if they mix up or commingle any of those inherited assets with other assets that they may have with a spouse, then if they subsequently get divorced, they may lose a significant part of the inheritance. What a lot of parents do, and a lot of parents like the idea of, is leaving their child's inheritance to what I'm going to call a child's inheritance trust. And because you want them to be able to absolutely control their inheritance, you'll name your child as the trustee of their trust, but their inheritance will initially be set up in in the terms of Tim as trustee of the Tim Inheritance Trust. And it'll make it a little harder for Tim to actually commingle or mix up those assets with other assets Tim may have with a spouse. So if Tim subsequently gets divorced, he keeps his trust. Tim and his spouse split other assets they may have acquired during the marriage. So a little more divorce protection there. The wife asked the question, well, couldn't Tim just, if he's the trustee and the way we're talking about giving Tim total control, couldn't he just remove the assets from the trust and then go commingle them? And the answer really is yes, but at least you've set it up so that if Tim just keeps those inherited assets in his trust, they'll be divorce protected as long as they're in his trust. So they did like the idea of setting things up so that each child would have their own trust, provide a little bit of additional divorce protection. All right, and then we asked the question, okay, after you both pass away, we've established that everything goes equally to the three children's inheritance trust, but who's going to be in charge of making sure that when you both pass away, things get handled and distributed equally to the three children's inheritance trust? They said, what are our options? I said, well, it's kind of common for adult parents to designate maybe one or more of their adult children who are responsible to fill that role. Some people do select another relative. Some people select a corporate trust company. They're like, no, our oldest son would be perfect for that job. Our kids get along great. And they didn't pick their oldest child because he was the oldest, but they picked him because he's responsible. He lived nearby. He's organized. He had good relationships with all of the other children. So they picked that oldest child to be in charge of making sure everything goes to the three children equally. That oldest child may be responsible for selling the house after the parents pass away, dividing those proceeds up, dealing with financial institutions and brokerage firm, making sure the assets get divided up three ways, filing a final tax return for that surviving parent to the extent that tax return is necessary. So those are the kinds of things that person that you designate to handle things when you pass away. Some people call it an executor when there's a will involved. Some people call it a trustee when there's a living trust involved. More on that later. Okay, so now that we've established what they want to happen after both spouses pass away, let's back up and talk about what happens when one of them passes away. I think most married couples have never really given that any significant thought. So they just kind of assume that when the first spouse dies, everything goes to the surviving spouse. But it's not always that simple. And let's start with the two options that they have. Let's call this couple John and Jane. And maybe for purposes of our hypothetical discussion, I say, John, let's just, how about if I knock you off first? You're a little older than Jane. You're a man. You think you're going to die earlier. It works the same way regardless of who dies first. But, John, I'm going to kind of knock you off first for purposes of our example. He says, no problem. So I'm like, okay, you have $6 million. The way the law looks at that in your circumstances, John, you have $3 million. Jane, you have $3 million. That together makes up $6 million. So if John dies first, then all of John's documentation will determine what happens to John's $3 million because Jane will continue owning her $3 million. So I said, John, you got two options. And actually is more than that, but let's start with the common two options. I said, John, you could just leave your $3 million outright to Jane. That's pretty simple. Each of you has $3 million of this $6 million. John dies. John leaves his $3 million to Jane. Now Jane has the entire $6 million. It's really simple. And so they like the simplicity of it. They want the surviving spouse to have control and access to everything because they worked on this together. But they said, are there any cons to that? Well, I was like, let's talk about this potential remarriage risk. And it's not just a remarriage risk, but most people understand it when I tell them something like, John, you could leave your $3 million to Jane. Jane now has the entire $6 million that she owns, and she can do whatever she wants to with it. Yes, it can be set up now so that when Jane later passes away, it can go to the children. But quite frankly, John, if you leave all of yours to Jane and Jane owns it all, she could change that distribution schedule and really disinherit all of your children. So they kind of said, we don't envision the survivor of us, but doing something like that. But are there other options? So I was like, yes, there's let's look at the second option. The second option, which provides the children a little more protection from the surviving spouse doing something silly or stupid or getting influenced by someone, is John, when you pass away first, for example, Jane still owns her 3 million. But this other option is John, you can leave your 3 million or whatever it is to a trust. Maybe you name Jane as the trustee of that trust. Maybe Jane's a co-trustee with one of the kids. Maybe somebody else is the trustee. But perhaps you provide that your 3 million goes into a trust when you pass away. Jane gets the income from that trust for the rest of her lifetime. Maybe Jane can use principal for her needs for the rest of her lifetime. But when Jane later dies, what's left of your $3 million, or quite frankly, what it may grow to, must revert back to your children. Jane can only change where her part goes when she dies. Once John dies, his part is fixed or irrevocable. It's in a trust for Jane for the rest of her lifetime, but when Jane dies, those assets must revert back to the kids. So they said, well, is there any tax difference to that? And yes, there is a tax difference to that. I'll get to that when I talk about taxes in a minute, because that's one of the important things that they want to address. All right, so let's keep going here. I said, we'll come back to that decision and let's move on to some other decisions. Let's talk about all the power of attorney stuff. Said John and Jane, all we've talked about up until now is what happens when you pass away. Not only when one of you passes away, but what happens when the survivor of you passes away. But now we got to talk about, who do you want to make it easy for to be able to handle your money and make your medical decisions if at some point during the rest of your lifetime you can't make those decisions for yourself? If you don't have all of the legal planning in place, it's possible that your family members may have to sue you in a court proceeding if you get to a condition where you can't sign your name to sell a vehicle or access your IRA account when it's necessary. And your survivors will have to sue you in a court proceeding, have a judge declare you incompetent, have a judge appoint a legal guardian for you so that that legal guardian can then transact for you while you're alive but incapacitated. They said, we'd like to avoid that if we could. And so most people avoid that. Just about everybody who puts their legal affairs in order does these powers of attorney. There's usually two of them, one for financial matters. Sometimes it's called a financial power of attorney, sometimes a general power of attorney, sometimes a durable power of attorney. Sometimes it's called just a power of attorney. But anyway, with that power of attorney, you can designate who do you want to make it easy for to be able to handle all of your financial business if you're in a condition where you can't handle things for yourself. And I went ahead and told them, look, most married couples appoint their spouse as their first agent, and then they appoint someone else as the backup agent in case when you can't do things for yourself, your spouse isn't available to do things for you. So they quickly said, yeah, we agree with that. We'd want our spouse to be our agent on our financial power of attorney. And then they initiated the conversation about, yeah, well, we'd also like our oldest son, if he's going to handle things when we pass away, we'd also, he's really responsible and, does a great job. We'd like him to be this alternate or backup to our spouse on our financial power of attorney. So we got through that. We said, what about all the healthcare decisions that may need to be made for you in the future? You might be in a surgery. Doctors need to talk to people about treatment decisions. Someone may need to go get your medical records. Who do you want to, make it easy to be able to handle all of those healthcare decisions? And they said, yeah, we'd want our spouse, we'd want our spouse making our decisions for us. And then if our spouse isn't available, we'd like our daughter, she's a nurse, we'd like her to be the backup on our healthcare power of attorney. Sometimes it's called an advanced healthcare directive, several different names for it. And then they said, does that cover the life support machines decision? I said, well, let's talk about that one too, because you as the patient have the right to make your decision regarding life support machines. So many people document their wishes. In fact, many people sign documents relieving your survivors from having to make that decision to terminate your life if you're in that profound vegetative state and there's no chance of recovery and the machines are serving only to artificially prolong the dying process. By signing a living will, you can document, direct your family, direct your doctors to honor those wishes so that if you are in that profound vegetative state and there is no chance of recovery and the machines are serving only to artificially prolong the dying process, by signing that living will, You can direct that your family and physicians honor your wishes to have those life support machines withheld under those circumstances, but provide you with enough medication to be comfortable. John made a joke, can I stay on life support for 2 weeks, and so sometimes people ask about that because they're concerned that the life support machines may be taken off too soon. So we have a conversation about that. In fact, we specifically talk about some of the elections that he can initial on his living will, on his healthcare documents regarding nutrition and hydration and some of those things that people like to document on their decision about whether life-sustaining procedures would be withheld or withdrawn. So we got through that. Next, I said, let's talk about taxes for a minute. I said, John, you've mentioned 3 or 4 times that you want to make sure that taxes are minimized. We're going to talk about estate tax, we're going to talk about income tax, and we're going to talk about capital gains tax. First, let's talk about the estate tax. You have a $6 million estate. And these days, here in 2025, when I'm making this video, we have something called portability, which generally speaking allows a married couple, to utilize 2 estate tax exemptions fairly easily. And we have a large estate tax exemption, certainly larger than we've had in the 30 plus years that I've been doing this stuff. The estate tax exemption for 2025 is $13.99 million. So with portability and with the right planning, married couples really can shield $28 million from the federal estate tax. And so, John and Jane made the typical jokes. We'll call you when we win the lottery. Be a nice problem to have, but we don't have it. So they have their $6 million estate. They could shield $28 million from the estate tax. So they didn't need to do any kind of take advantage of any gifting strategies or anything like that in order to avoid federal estate tax, because it's very, very unlikely that they're just not going to be subject to it. Next, let's talk about the income tax. Of their $6 million estate, they had about $1 million in IRAs between John's IRA and Jane's IRA. And so they had about $5 million of other assets, things like brokerage accounts, home, real estate, maybe even an LLC or a business, vehicles, bank accounts, CDs. So I said, here's the deal on the income tax aspects of estate planning. I said those IRAs that you have, those traditional IRAs, I'm not talking about Roth IRAs for now, I'm talking about traditional IRAs. I said somebody's going to pay income tax when they get those IRAs. Either, John, you have a $600,000 IRA. When you take distributions from that IRA during your lifetime, you'll pay income tax. If you die and name Jane as the primary beneficiary, and then she rolls that into an IRA in her name, and then when she takes distributions from that IRA, that'll be taxable income to her. And if those IRAs are still around after both of you pass away, then your children will each inherited IRAs, and they'll have 10 years after the surviving spouse passes away to take all of that money out of those inherited IRAs and pay the income tax. There's really no getting around the income tax on a traditional IRA. Sure, they could leave those IRAs to charity and avoid the income tax, but they didn't want to do that. They wanted to maximize what stayed in the family. So there is an income tax consequence of leaving an IRA to your surviving family members. But really, I said, you know what, everything else from an income tax perspective, generally speaking, an inheritance is income tax free. If your spouse, if your kids inherit your bank accounts, your brokerage accounts, even the value of your home, other real estate, a business, that all goes to them income tax free. We'll talk about capital gains tax in a minute. But an inheritance generally is income tax free. Yes, they realize that their survivors will pay income tax on distributions from IRAs that they inherit, but other assets are income tax free. Next, let's talk about the capital gains tax discussions, because they did have a brokerage account that had some assets that had appreciated significantly in value. They had a piece of rental property that had significantly increased in value. So they said, Paul, we've gotten hit pretty hard with the capital gains tax when we sold stuff over the years that had grown in value. What's the deal with that in our estate planning? So I said, here's the deal. Remember when we talked about what happens when one of you dies? You have $6 million. John, remember I knocked you off first. You have $3 million. Jane has $3 million. Well, let's say you die first with your $3 million of assets. And John, when you die, that $3 million of assets, even if you only paid $1 million for those assets that are now $3 million, all those assets will get a step up in basis When you pass away, the new basis will shift from $1 million to $3 million, the value on the date that you die. You don't have to do anything for that to take effect. It just happens as a result of our tax law, that step up in basis. And quite frankly, John, if you live in a community property state when you die, not only does your part of the community property get a step up in basis when the first spouse dies, but all of the community property gets a step up in basis when the first spouse dies. To me, that's a real advantage to people who live in community property states, is that all of the community property, both spouses' part, gets that step up in basis when the first spouse dies. But here's a very intriguing tax picture for you that I want you to realize, John. I said, remember, there's two ways to leave things to your spouse. You can leave your things to your spouse outright, or you can leave things to your spouse in trust. I said, if you leave things to your spouse outright, then you'll be including everything that's yours, John, into Jane's estate. Jane's estate, if you leave her ownership of everything that you have, will include the entire $6 million of assets. And then after you die, John, Jane may live for another, who knows, 5, 10, 20, 30 years. And then because all of the assets will be included in Jane's estate, all of the marital assets will get another step up in basis when Jane dies. The new basis will be the value on the date of Jane's death. They really like the fact that I call it that double step up in basis. Not only would there be a step up when John died, but because John lumped all of his assets into Jane's estate, the key there is all the assets in Jane's estate. Yes, they're subject to estate tax, but they're under 28 million. And so the fact that they're in Jane's estate means they all get a step up in basis when Jane dies. I said, on the other hand, John, if you want to provide your kids with more protection from the remarriage risk, should Jane remarry, it shouldn't have to be remarriage for this remarriage risk to be exposed. The potential problem is Jane, if whatever Jane owns, she could, in theory, direct all of those assets that she owns to people other than the children. But so I said, John, if you do set things up so that when you die, things go in a trust for Jane to protect it for the kids to get it when Jane dies, those assets then will not get another step up in basis when Jane dies, because those assets will not be in Jane's estate. Only the assets that Jane owns, her $3 million, would get another step up in basis when she dies. She doesn't own those assets that are in a trust for her, protected to go to the kids when Jane dies. So they kind of looked at each other and they're like, yeah, we realized there would be protection for the kids in the event that one of us died and the first spouse to die left their assets in a trust for the surviving spouse. But John said, I understand all of the pros and cons. I really like the idea of getting that double step up in basis. I really want to set this up so that the least amount of tax is paid. They said, we're willing to take the risk of leaving everything to the surviving spouse, knowing that the surviving spouse could disinherit our children, but we just don't think that's going to happen, and we want to get the tax advantage of the double step up in basis. Let's do it that way. Okay, so it's there's that. You have to understand that combination of asset protection for the kids versus tax consequences to the spouse, to the kids, and make an informed decision. All right, so once we got through the taxes, then we talked about, well, John and Jane, there's two different ways you can set all of this up. The traditional way, the customary way, is that you get wills prepared for each of you. John, your will says, when I pass away, I leave everything to Jane, but if Jane dies before me, I leave everything to my children's inheritance trust. And when you leave everything in your name and rely on wills or last will and testaments to provide for the disposition of your estate, the fact that you leave assets in your name means that there's going to be a probate when you pass away. So John, when you pass away, Jane will get all of the lawyer help and go through that court and attorney involved probate proceeding to get your name, John, taken off of everything pursuant to your will and have all that transferred to Jane. And then when Jane subsequently dies, maybe years later, the kids will again go through that court and lawyer involved process. They may, they ask, what's that like? And yes, it's thousands of dollars. Sometimes it's tens of thousands of dollars. Sometimes it's more. It's always months. Sometimes it goes into years as to how long it takes. So they said, is there another way to do it, a simpler way? And so we talked about the second option of how they will set all of this up, and I'll call that their living trust plan. I said many people, John and Jane, they set up their John and Jane revocable living trust, and they transfer assets like their home, like their business, like their brokerage account. They transfer those assets that would have to go through probate if they remained in your name when you died. We transfer those assets from your name to your trust now. So your brokerage account, so your home gets retitled from John and Jane to John and Jane as trustees of the John and Jane Living Trust. And things that are titled in the name of your trust when you pass away, they don't get frozen. They don't have to go through that court and attorney involved process. So if, for example, if you set your living trust up so that the surviving spouse stays in complete control of everything, and there's no carving out of another trust when one of you dies, then, and just like you want to do to make sure you get the double step up in basis, then John, when you have everything set up the right way, titled in your trust, and your beneficiary designations on IRAs and life insurance are set up correctly, then really when John dies, there's very little, if anything, that Jane needs to do. She just stays in charge of that trust. Nothing needs to be retitled. Nothing needs to go through the courts. Attorneys typically don't have to be involved. And then when Jane dies, you've designated your oldest son as the successor trustee of your trust. He could stick that for sale sign in your yard the day after both of you pass away and sell that house, start dividing up all the money at the brokerage accounts, at the brokerage firms, without having to go through that court and attorney involved probate process. So they, like many people, opted to set up their John and Jane revocable living trust. They wanted to eliminate the need for all of that court and attorney involvement when each of them passes away, which would be necessary if they left their assets in their name and relied on wills to transfer their assets when they died. All right, so in addition to creating the trust and what we call funding the trust, do the paperwork to transfer their real estate to their trust, we also want to make sure that based on the objectives that we know now, we want to make sure that all those non-probate assets like IRAs, 401ks, some people own annuities, they name their spouse as their primary beneficiary and their 3 children as the equal contingent beneficiaries. Jane asked, what about, this diamond ring that I want to make sure certain people get it? I've got some things I want to go to my daughter, or certain things I want to go to my grandchildren. So we talked through the different options they have for dealing with that personal property that's non-titled. And so we talked about in different states have different rules on this. Some states specifically allow for these kind of informal, tangible personal property memorandums. Others don't. But nonetheless, really what anybody could do is document on I'm going to call it a tangible personal property memorandum, which may or may not be invalid. But for many people, as to those personal property items like jewelry and furniture and artwork, a lot of people just feel like because the kids will honor the parents' wishes, the parents just need to document their wishes. So we showed them the tangible personal property memorandum, which does provide guidance to their survivors regarding the distribution of specific items like furniture, artwork, jewelry, family heirlooms, collections, or other personal effects. They said, we can just do that informally. We'll document. Great that you supply us with kind of a form or template that we can use, add to, take away from. We feel like our kids will honor our wishes as long as we document it. Even if that documentation is not a legally valid document, they're going to honor our wishes. So kind of as I recap there, I said, well, sounds like here's what we've got. You've got if you can't sign things during your lifetime and handle financial affairs, you'll make it easy with your trust and with your financial power of attorney so that your spouse can do all of that for you. If your spouse isn't able to be your oldest son, if you need medical decisions made for you at some point during the rest of your lifetime, you'll make it easy for your spouse first, and then your daughter, who's a nurse, to be the backup to your spouse for all of those healthcare decisions. You'll document your wishes regarding life support machines, and then you'll create your living trust, and we'll work on titling assets in that trust so that the probate is eliminated. The trust will say that you can do whatever you want to with all of the assets for the rest of your lifetime. When one of you dies, nothing changes. The surviving spouse stays in complete control of everything. And then as long as the surviving spouse doesn't make any changes after both of you pass away, everything will get that step up in basis and assets. Your oldest son will be involved in dividing up the assets equally among the three children's inheritance trusts. Again, the purpose of the inheritance trust is not to restrict your children from being able to do whatever they want to do with the inheritance, but assets in that trust will remain owned really solely by your child and provide that divorce protection. Helps keep them from commingling the inherited assets with other assets that they may have with a spouse. So they're like, sounds great. How do we get started? We give every one of our clients an online vault or an online portal where they can, input all of the correct spellings of all the family members' names, all of the assets that they have, and they can act. And then, once all of the documents get signed, we upload that so they have all the physical papers. They have an electronic version of everything, and so things are accessible. We customize all the documents. As we customize them, we set up more Zoom calls. Let's put the documents up on the screen, point out where we customized all their different decisions that they made. Once we all feel like it's 100% perfect, then we work on getting everything made official and getting all the signing done in accordance with all the appropriate rules. And then we take it from there. And then, we tell them if there's any major changes to your family circumstances, let's revisit that, make sure we don't need to do any kind of amendment or update. The wife said, do you mean every time we buy a new home or we get a new brokerage account or we start a new business, we've got to amend our trust? I'm like, no, you don't. So as you acquire assets in the future, if you buy a new home, if you start a new business, if you open a new brokerage account, you don't need to amend your trust. You just need to title those assets in the name of your trust. So when you set up a new brokerage account to do some investing in the future, just title it John and Jane as trustees of the John and Jane Doe Trust. There's instructions in your portfolio on how to do that. Don't need to contact us or anything. Your trust just says trust says many things, but it says when you both pass away, whatever trust assets exist are to go to the three children equally. In your case, we don't have to individually specify any of your assets in the trust instrument. We just want to make sure that assets are titled correctly when you pass away and your trust is, as we call it, funded. Okay, so hope that helps, giving you that case study. We'll do a lot more in the future. We'll see you next time.